All rise. The Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable Scott Makar, Judge, presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, everyone. We're very pleased to be here with our Palatka City. We've got 3 cases today. I'd like to first of all introduce our panel. As you just heard, I'm Scott Makar, the presiding judge. I'm from Jacksonville. We have a new district, a redrawn district, the 5th District Court of Appeal. It now includes Jacksonville. So 2 of us, Judge Jay and myself, who used to be on the 1st District Court of Appeal, are now on the 5th District Court of Appeal. And one of our newest judges, to my left, is Judge Joe Boatwright, who is familiar to many of you in the courtroom here, longtime trial judge here. And we know we have a full day of the cases. We also have the students from school for the first case and also for the second case. I think Judge Boatwright may know the audience better than me and might have some other folks to acknowledge.
I think we have our sheriff here, Gator Deloach. We have our clerk of court, Matt Reynolds, back there. We have the president of Putnam County Bar here, Alex Sharp.
All right, well, thank you all for being here. This is a real pleasure for us. We really appreciate the circuit opening up a facility for us, the county opening up a facility for us. You'll see students that the lawyers will soon be making their arguments, and they do it in a very civil way. We give them 20 minutes per side for their cases. And the appellant who goes first is allowed to reserve some of the time of the 20 minutes for what's called rebuttal. So appellant, Mr. Gussie, would you like to reserve any time?
5 minutes, please.
Great, thank you very much. You may proceed.
May it please the court, I'm Bill Gressley from Jacksonville on behalf of appellant Michael Wosiski, and he was the former husband below. The appellee was the former wife. A couple of quick things. This is the first oral argument I can ever remember looking down at the judges.
Well, don't get used to it.
I was going to say this is disconcerting, and also I wanted to let you know I have hearing aids, that I have an app on my phone that allows me to adjust direction and volume. So if you see me messing with my phone during the course of oral argument, I am not posting on social media. I am making sure that I can hear and not overhear, as the case may
Well,
be.
just so everyone knows, this is a live oral argument. It is on YouTube.
Yes, sir.
It's live on YouTube, so take
And
note.
it gets archived as well, right?
It should, yes.
Yeah, if you want to watch yourself watching oral argument, you can probably do that in the future. All right, Your Honors, this is actually a very simple case based upon what actually the parties agreed upon. This past January, we celebrated the 98th anniversary of the Florida Supreme Court's decision in the Blackshear Manufacturing case, which I have cited in every contract, brief, or memorandum of law that I've ever written, because it really sets the standard for what we do when we look at a contract. The order under review, which appears in the record at 305 through 311, is called the consent judgment resolving all remaining issues and modifying final judgment. This is, I think, the initial final judgment bifurcated several issues, and this is the third one. The court sent the parties back to mediation 2 separate occasions, and so the one we're here about was entered into in 2014. The initial final judgment was 2013. And paragraph 1 of the order under review specifically says anything we were not modifying here, anything that's not specifically modifying, all the prior orders and judgments are still in effect. The initial final judgment granted the former wife the exclusive use and possession so long as she was unmarried and lived in the former marital home with a child, made her responsible for all of the payments due. And that changed in the consent final judgment that we're dealing with. The practical aspect, as Blackshear teaches us, that the interpretation of a contract is not what the parties subjectively meant, it's what they said. And it also said you should interpret a contract consistent with the reason, probability, and the practical aspect of the transaction. Page 14 of the reply brief gratuitously comments that my client chose not to make as much money as his client, and therefore that has some relevance. Well, the only relevance it has is if you're looking at the practical aspect of this transaction, my client traded, and I'll get to this in a second, a bundle of things, including his right as a tenant in common to any equity in the former marital home, which he was awarded under the initial consent judgment.
Well, isn't the only issue here is the payment, the last payment of the home that the wife is supposed to pay, right?
Which was 4 years overdue.
Okay, so what did your client do in those 4 years to enforce it?
He didn't have to do anything. He sat.
But that's not my question. What did he do? He sat for
well,
4 years and waited?
What he did in the consent judgment was gave up, let's see, they had paragraphs 3, 4, and 5 dealt with child support, child health insurance, and uncovered medical expenses. Paragraph 7 and 8 dealt with vehicles. Paragraph 9, allocation of debts. Paragraph 10, tax return. And paragraph 11, multiple agreements regarding corporate ownership in which my client waives rights.
Well, counsel, those are all wonderful things, but we're here today on a separate issue.
Well, that's part of the analysis that's required here, because the other side has said, oh, this was not a condition precedent to making a payment. The other side's interpretation of this agreement is that the provisions that were explicitly negotiated and explicitly placed in paragraph 6 and 14 as to the timing of these payments were meaningless. My client had no obligation whatsoever to do anything except what he agreed to do in that consent final judgment, and he gave up multiple claims, resolved all the issues that I just started reciting, including in paragraph 17, he had a pending appeal. He had a pending appeal that he dismissed as part of this, so he fully performed. He sat and did what exactly the agreement called for. He gave up all these things, the former
hitting the issue spot on in that the Thomas versus of the final $25,000 payment. She paid $5,000 on May 24th, 2014. She paid $5,000 June 21st, 2014. She paid $5,000 July 21st, 2014. $10,000 December 31st, 2014. $25,000 December 31st, 2015. And then she pays $12,000 of the $25,000 in 2016. And at that point in time, I think Justice Carr was hitting it right on the nail when you were asking about what about the $62,000. And if you read back in the transcript, the trial court said the same thing. Well, if that's the case, in the record transcript of the June 9, 2021, it's between 1157 and 1176, page 9 of the transcript. The court said, well, if that's the case, then I guess he owes her $62,000. Ms. Price, how much? The court, $62,000. Ms. Price, again, Your Honor, our position is the consent, the third judgment, consent judgment, and goes on into the same argument about what he gave up. This was clearly the whole point of what we're here about today is the house. This was an equitable distribution of the house.
Could you remind me because I've forgotten actually that there was the $12,000 payment on time.
Yes, sir.
Okay, so the check, your client then sent a check with interest, correct, to the appellant?
Yes,
3 or 4 years later. That check, I assume, was never cashed.
correct. It's still sitting in the, held in trust in the office of Mr. Wazinski's former trial counsel who appeared for this hearing. So she clearly tendered what was due plus interest. If the court were to rule otherwise, I think she would be out the $62,000 because as we're discussing, the equity court can enforce, sign this deed as a matter, but the court doesn't have the authority to say pay $62,000 back. My client would have to file a separate suit, and at this point today, the statute of limitations would bar her. She'd be the one that'd be out. By the same token, if my client hadn't tendered, Mr. Wazinski would have had to file a separate suit to get the $13,000 he was due on that balance. So I think what we're here today is to do equity. In the context of this case and the timeline, her failure to pay $13,000 under controlling case law should be excused. It was not a material breach. Nowhere in the contract is time stated to be of the essence. The substantial compliance, or that term.
Explain that to me, counsel. You said it was not a material breach. Do you think it was a breach, just not a material breach?
Yes, I would concede it was a breach of the contract, just like these other contracts where we encounter delays, whether it was moving out of the house or whether it was making a payment a little late.
So what takes it out of the realm of being a material breach?
I think what takes it out of the room of being a material breach is that we had substantial compliance that she'd paid 83% of what was paid for. And I think that's the key difference in this case. We're not asking for in the brief, the appellant's arguing that we're asking for a modification of the contract. I would argue that it's the appellant who's asking for a modification. They want the court to find that there was a time was of the essence clause. They want the court to find there was a forfeiture clause. If you miss any one of these payments, if you're $1 short, if you're a day late, you forfeit everything, and you give me back a half interest in the house.
What was the interest rate?
The interest rate,
The reason I ask is essentially it's a $12,000 plus loan.
it was calculated at the statutory interest as it applied during that period of time.
If you recall what it was. I'm not pop quiz.
I honestly do not. I think it was in that 4 or 5% range. I know it is spelled out in the calculations in the pleading. I laid out what the interest was in that calculation, how it was arrived at. By the same token, if you were to talk about hardships at the time, my client's tendering payment, I think interest rates were around 1 or 2%, and now it's going to be a completely different ballgame.
Did the appellant ever, or did you ever raise a point of, like, hey, you sat on your rights? You allowed it, you stood by while the delay occurred and nothing. Is that a part of the record?
I cannot expressly recall having argued that. We never felt that the time or any delays incurred, and I think the record shows that there was an initial motion filed by the plaintiff where she had not made a formal tender, and the reply from the appellant raised, when he was pro se, raised that Piro case, which is clearly a commercial case having to do with a partition of property, and that's really the hat that the Panero case that the appellant's been traveling on this whole time, saying haha. And in that case, there is an express forfeiture clause. Panero specifically laid out, okay, we're partitioning property, $200,000 is due on this day. If you don't pay it by that, you get one 15-day extension, and if you're not squared up by then, you forfeit it. And in the Panero case, in a commercial context, the court said the parties knew what they were doing, that's what they bargained for, you're forfeiting it, because the contract said it. There's nothing in this consent final judgment, which was a consent judgment the parties negotiated, which anticipated or has any kind of forfeiture language or any time is of the essence language. So what we would be asking the court to do today is to find that the trial court was proper in ordering Mr. Wazinski to sign the deed that had been called for transfer, and that the payment has in fact been tendered, and that there was no material breach excusing performance on the appellant's part.
Has everything been stayed at the trial level? I mean, it's just status quo at the trial level, or has there been any action on the judgment?
Everything's been stayed. The trial court, there is an order in the record. Once an appeal was filed, the trial court found it did not have jurisdiction to proceed any further in this regards.
So your client is still living in the home?
Correct. And I would also note in the context of this case, this is very much still an ongoing case, that we're talking about a 10-year-old dissolution where there's still a 16-year-old and a 17-year-old in the home. As recently as June 2020, we tried a supplemental petition in front of the trial court. So this case is far from done, and I think that factors into the family law context of, this delay is just part of the proceeding, part of what's going on. And I'm ready to answer any further questions. Otherwise, I would rest.
Thank you for your
Thank you.
I find it interesting that council raised the supplemental authority issue, which got served last night at 6:45. Those cases on
Well, if there's something served at 6:45 last night, I know I haven't seen it.
Well,
So
I looked at it, they add nothing to the discussion. This is not a case in equity. I'd like to point out that the Gray versus Gray case out of this court in 2021 had the following quote: "While it seems unlikely that the parties actually intended for the retirement fund transfer to be contingent upon the horse paintings," that's a buzzword for certain racehorse memorabilia, "there is nothing unclear about the terms of the agreement in the final judgment of dissolution. Both mandate in plain terms the former wife was to transfer the retirement funds after the transfer documents for the horse paintings were completed." This is a family law case. This is an agreement that was enforced as a matter of law. We don't set aside contracts based on equity. There was never a tender here. A tender, and I've discussed this in the briefs, a tender requires a mirror image. This was an offer to modify the parties' agreement. To say that a payment plan that was explicitly provided for in an agreement with multiple other issues and give and take was a non-material element is to stretch language beyond recognition. Yes, sir.
And the question I was going to ask you before, Mr. Grussley, I wanted to explore substantial compliance. And I know this is hypothetical, but assume that on January 1st, 2017, she made the $25,000 payment a day late. And according to your position, in violation of paragraph 14. Would your client still be entitled to relief? Or would that be a substantial compliance?
I don't think substantial compliance applies in this context because the parties have an explicit agreement. If you collectively decide that this really doesn't mean what it says and that the timing of the payments was just some optional thing that the former wife could take or leave, my client fully performed his end of the bargain as soon as this consent judgment was entered.
And thank you, Mr. Grussley. But as to January 1st, 2017.
And I think legally the answer is the same. Would we have a whole different approach to this case? Would my client, would we still be here? I can't answer that. I really can't answer that. I can tell you that everybody would tap dance hard to try to figure out a way around it. But legally, this is the same thing as the Gray case out of this court in 2021.
Did that sprinkle of equity wouldn't apply in my hypothetical?
How can I answer that, Judge? I don't think you have the right in a Chapter 61 case to set aside the explicit agreement of the parties in contract.
But if he's getting interest, where's the harm to your client?
He wasn't getting interest on any of those other payments. It was a payment to be made to him within a 2-year
Right,
period.
paid on time. I'm talking about the one last payment. He got interest in the check. He's been made whole. He's actually
He has not been made whole. He was a
maybe
half.
greater than whole. If the interest rate was
No,
higher.
he was a half owner in this house as a matter of law. He was a tenant in common with the former wife. And the transaction, the agreement that they made covered her getting his interest, and it's not a
So
forfeiture.
under Judge Jay's hypothetical, your client wants his kids and wife to move out of the house
No,
because she was
no. The original final judgment provides that she stays there in that house as long as she's unmarried and their minor children. And opposing counsel just pointed out there's still 2 minor children with whom my client has 40% of the time sharing. So, no, we're not. We're just saying that he's never lost his status as a tenant in common. She did not comply with the agreement, and this is not a tender. This is not a case of equity. She's not forfeiting anything. She intentionally gave up her right to finish this.
Paragraph 14 is entitled Equitable Distribution Division.
That's because that's what we call any distribution between the parties in a dissolution case. We call it equitable distribution. And the reason we do that is because that's what the statute calls it, and that's what from time immemorial dissolution cases have called it. It doesn't mean, well, let me say it this way, Judge. If the court decides that this really isn't a time of the essence, please write an opinion and explain why Gray versus Gray is different than our case, because I don't see it. And this is, this is what I do, is come make arguments to you, and sometimes you agree and sometimes you don't. I understand that, but we need some guidance if you don't believe that this contract meant what it said.
I think your time is up.
I'm 22 seconds over. I'll pay you back next time. Thank you.
All right, we we thank you both for your excellent counsel.
Do you want any interplay with the students at this point, or?
What we're gonna do at this time is we wanna recognize the students here, and thank you all for being here. Hopefully you'll be either inspired